for Shreya Singhal case is this was to challenge on constitutionality of section 66A, 69A, 79 section basically of IT Act 2000. So IT Act ro tinta section ko constitutionally validity darkar. So you already know section article 13 what it talks about. It gives judicial review, right? हाँ कि नहीं बेसिकली जुडिशियल रिव्यू रा गोटे कहूँ कि व्हाट इज नॉट लॉ करेक्ट नो आर्टिकल 32 आर्टिकल 226 that will talk about judicial review but at least article 13 gives a hint like which will go for judicial review. That means if a state basically the state रो ड्यूटी कोन से तम फंडामेंटल राइट जोटा अछि ताकू से प्रोटेक्ट करिया कथा बट जदी ता अगेंस्ट से कोनोसी लॉ तयारी कला देन दैट लॉ कैन बी कंसीडर्ड टू बी void or it can be struck down or it can be known to be ultra virus when that law is violating any of the fundamental right. Correct? No, that means when I'm saying article this IT Act 2000, that means this is a statutory. Correct? No, because this is a law that has been made by the parliament. That means if that law is violation is making a violation for any of the fundamental right, then it will go for what? Judicial review hongi nahi. According to what? According to article 30. Then that judicial review process and all that will be 32 or 226. Either you can approach to Supreme Court or you can approach to High Court. Coming to this, now freedom of speech and expression in realm of internet and social media. So this already we mentioned in article 1 clause subclause A. So background. 2012 रे two girls were arrested under section 66 of IT Act 2000. Why? Because they did a comment on Facebook against there was a bond डाकरा आस्तिला for the what शिवसेना रो जो चीफ थिले बाल ठाकरे तांको डेथ लागि गोटे बंद डाकरा आस्तिला राइट. सो सेथि पई से माने कोन करलो तांको पुलिस अरेस्ट करनेला. नाउ हु इज पुलिस? पुलिस इज अगेन स्टेट, राइट, कमिंग अंडर स्टेट अकॉर्डिंग टू आर्टिकल 12 हां कि नहीं. Okay, now so seeing this thing, when these two people got arrested, right, these two girls they got arrested, there was a protest in the public. Now Shreya Singhal, that guy was one the law student, okay, so he filed one public interest litigation against the arrest, thinking this arrest is violates article 19 clause 1 subclause A. Hence we need to repeal the section 66A of the IT Act 2000. Is that clear? The background is clear, right? Okay. Now coming to the legal issues of this. So the legal issue, this section 66A, 69A. Now the question to the court is whether it is unconstitutional. Second, whether these two sections of the IT Act 2000 is violative of article 14, article 19 clause 1 subclause A and article 21 right to life. Third one, the language of this statute, जेहेतु एटा गोटे लॉ रु तयारी हेछि, that's why we are mentioning as statute. The language of article 66A is somewhat misleading and it can promote arbitrariness. So जेहेतु एटा गोटे arbitrariness ही पारे, जेहेतु एटा गोटे it's like not a clear sign like कि कोउटा को तमे कहिबो कि को मेसेज गोडा होछि incitement माने hatred तयारी करिबनी आ को मेसेज गोडा hatred तयारी करिबो ता विषय कोनोसी क्लैरिटी नाही. Correct? No. So that's why it is considered to be the language that has been used in section 66A is considered to be vague. So these are the legal issues that were like there in front of the Supreme Court. Now argument by the petitioner. तो श्रेया सिंघल का तरफ रू कौन थिला argument? So the first argument was section 66A. It is not under the ground of reasonable restrictions. So we already talked about, correct? No, 19 clause 1 subclause A रो reasonable restriction केतरे थिला 19 clause 2 रे. Then तमे मते को section 66A रे जो गुडा लिखा है that is through the social media. Social media रे तमे जदी किछि करूछ, correct? No, but से गुडा एठी जो गुडा हमें कहिले एथिरे जो थिला कि insult, injury, criminal intimidation, enmity, hatred. See, जदि एटा गोटे public interest रे होछि, then it is considered to be restriction against this. The restriction will be article 19 clause 1 subclause A रो restriction में पड़ाइसो 19 clause 2 रे. But एथिरे जो 66A रे जहा लिखा है से गुडा तो हमर एठी भी नाही. हां सेठी तमे क्लियरली मेंशन करतांदा कि reasonable restriction रे 19 clause 2 रे, even 19 clause 2 also applies to 66A of IT Act. लेट सपोज तमे परे गोटे अमेंडमेंट आनी था एंड सेठी तमे लिखि देता सो इट इज फास्ट कथा हला एथिरे रीजनेबल ग्राउंड ऑफ रेस्ट्रिक्शन रे सेक्शन 66 ए विषय कोनोसी चर्चा नाही नेक्स्ट आर्टिकल 19 ऑफ UTHR व्हाट इज UTHR anyone knows universal declaration of human rights right so tar article 19 रे सेठी कोन को ना freedom of speech and expression through any media that means UDHR which is a global roadmap for freedom and equality they also mention that in the article 19 of UDHR that there has to be freedom of speech and expression that has to be also done through any media now violation of article 14 now article 14 if you clearly read there is something called intelligible differentia why these words are being used because in article 14 it talks about two things one is before law everyone has to be equal that means equality before law correct
protection of law.
Second one talks about equal protection of law now to understand the second one you have to understand what is this intelligible differentia that means if you are saying equal protection of law for example got a child got a murder karichi and got a like adult maybe more than 25 years or 20 years see got a murder karichi then ethi child ku tame protect karibo while the person has to be go for law or liable for punishment correct no so that intelligible differentia has to be there so this violation of article 14 so now the Shreya Singhal case re petitioner je se कहउतंदी कि this section 66A it is also violative of article 14 how you are going to differentiate between citizen and netizen I already told no now netizen जो माने नेट रे जाई कि निजर व्यू देले से माने चार्ज रे बुक हे गले बट जदी सो में चार्ट अपरी रे बसी की कथा होचो related to any of the discussion सेठी तमरो कोनोसी तम ऊपर चार्जेस होउनी बिकॉज़ एटा जणा ही पडुनी you understood right why it is going against article 14 so three things I told about section 66 गोटे होची reasonable restriction because these are the arguments given by the petitioner one is related to reasonable restriction second one से कहउछन कि UDHR रे भी already अछि कि कोनोसी मीडिया रे जणे चाहिले किछि भी निजर व्यू ओपिनियन रखि परिबो that is through the UDHR United Declaration of Human Rights. The third one is related to violation of Article 14. Now, what is the respondent? तो जो opposition रे जो अछि तांकर आर्गुमेंट कोन ना गवर्नमेंट तरफ रु से भी आसे के आर्गुमेंट करिवे ना कि ठीक अछि आर्गुमेंट रो अगेंस्ट रे आमे भी आर्गुमेंट करबो ओके सो सेठी से माने कहउछन द लेजिस्लेचर they are the best position to understand and appreciate the need of the people that means se mane कहउछन 66A is correct why it is correct because this has been done through parliament and parliament through rehi that means it has a legislative competent also so the word here you will see legislative competent that means who are the legislature they are coming from the people through the voting right voting process right? That means jaha parliament re decision niya hoji seta lokko mananga pai niya hoji so they are saying this 66A is valid and it is to ensure that there has to be peace and it is the need of the people right so second argument re se kon douchani na it is mere there might be mere possibilities of abuse and that cannot make the section unconstitutional that means respondent कहउछनी हां ठीक अछि for example तमे कोठी गोटे किछि गोटे वर्ड पके देला कि गवर्नमेंट अगेंस्ट रे देन हठात पुलिस को लागिला कि पुलिस लेट सब पुलिस राउ तमरो शत्रुता अछि देन पुलिस देखिला कि भाई ये एमती किछि गोटे करछि देन दाको सेक्शन 66 ए अंडर रे बुक कर लिया यू अंडरस्टूड राइट दैट मींस arbitrariness because पुलिस रा तम सहित दुश्मनी थिला जोठी तमे बुक हे जाउछ बट जदी मु सेठी किछि गोटे वर्ड पुट करछि देन मु बुक होनी दैट मींस इट इज आल्सो वायोलेशन ऑफ आर्टिकल 14 जोठी तमे को चार्ज होउछि बट मते चार्ज होनी यू अंडरस्टूड राइट how it is violation of article 14 equality before law so it is creating a somewhat arbitrariness correct no that's why there is a mere possibilities yes there is mere possibilities of abuse but that mere possibilities should not be the reason for making the entire section to be unconstitutional this is what the argument given from the respondent then also from the petitioner there was an argument related to the vagueness of that section कि से जो word गोड़ा अछि जो wording गोड़ा अछि से गोड़ा proper नहीं so they mention this vagueness of the language cannot be a ground to declare statute unconstitutional as this is legislature competent and non arbitrary so से माने कहउछन this is not arbitrarily आमे एटा को यूज कर परिबो and ए जो लैंग्वेज गोड़ा जहां भी दिया है से गोड़ा properly discussion and voting द्वारा ही हेछि तो जेहेतु discussion हेछि and voting द्वारा ही से एक्टा पास हेछि that means there is a legislative competent is also there so you should not say like okay this is not legislative competent or aku ame unconstitutional declare kari debu let's talk about judgment. So in the judgment of section 66A provided by the Supreme Court, providing chilling effect. So this is where we will talk about doctrine of chilling effect. So what is the doctrine of chilling effect? So doctrine of chilling effect, I can tell you something like, for example, gote ठेकुआ, let's suppose ठेकुआ को राति रे गोटे रास्ता क्रॉस करियार अछि, you understood right? So से ठेकुआ कोन हला जेतले रास्ता रे क्रॉस करूची हठात तम बाइक रो लाइट पड़ी गला, देन से ठेकुआ बर्तन जानि ही पारुनी कि मु बां को जिबी कि डाहण को जिबी, you understood right? So similarly here, this is the situation arises where you don't know whether you have to speak or you don't have to speak. For example, article 19 clause 1 sub clause A, it gives you what? Freedom of speech and expression. But the same time this 66A जदि तमे एमिति कहू कहू कोन गोटे कहि देलो एंड तुमको चार्ज तुमको बुक कराय गला कि चलो तुमको बर्तन पनिशमेंट दिया हो, you understood right? That means तुमको डर लागिवो प्रतिटी कथा कहिया पूर्वरु तुमको आगो 2-3 थरा भाबियो पड़ियो कि मु कहिबि ना कहिबि ताटु बेटर मु चुप हिची. That means you are also, because of this 66A, you are not going to use this article 19(1) sub clause A. Is that clear? Okay. So because of 66, that means there is a chilling effect. मु जानि पाउनी मु वर्तमान कोन करिवि, मते गोटे आर्टिकल गोटे फंडामेंटल राइट अछि कि मु जहा चाहिबि कहि परिबि, किंतु एमिति किछि कहू कहू एमिति किछि न कहि दिए जोथि पे कि मते से माने कोन करिवे बुक कर देबे. That means because 66A अछि मु कहिबा को डरुची, करेक्ट नो, मु प्रॉपर्ली कहिबा को चाहि पारुनी. That means मु कहिबि कि कहिबिनी जानि पारुनी. That means मु गोटे हडल रे रह जाउची, गोटे टग ऑफ वार सिचुएशन रे रहउची जोथि कि मु कहिबि कि कहिबिनी सेही ସେଇଥିରେ ହିଁ ରହି ଯାଉଛି and ମୁଁ ମୋ ଆର୍ଟିକଲ କୁ ୟୁଜ ହିଁ କରିପାରୁନି, ମୁଁ ମୋ ଚଏସ କୁ ୟୁଟିଲାଇଜ ହିଁ କରିପାରୁନି. That means whenever I am talking about choice, it will go to article 21. Correct? No, I am not able to utilize my choice because of doctrine of chilling effect. So this section 66, it is providing a chilling effect, and the loose words of 66A, it will promote arbitrariness. For example, police asla, because of loose word अछि police asiki tomu bandi nei jibo and injustice to the society. Hence, the Supreme Court, they declared this 66A has to be struck down and it has to be considered to be ultra virus. That means it has to be declared as void. Is that clear? Okay. Now coming, this is regarding to 19 clause 1 sub clause A. What is related to section 14? So sorry, article 14. So there was also legal issues. It is also violated of what? 14. See, here doctrine of chilling effect, this is applicable to what? 19 clause 1 sub clause A and also 21. Correct? No, because tome toma life re choice को ही utilize कर पारनो, मते कहिबार अछि but मु कहि पारनी because of chilling effect. So 14 and 21, sorry, 19 clause 1 sub clause A and 21 को violate कलारु ताको struck down कराहेला. What about article 14? So on violation of article 14, which is talking about intelligible differentia, Supreme Court talk, no, actually it has intelligible differentia. Through internet, one can get in views in nominal cost than other medium, hence it is not violated. That means what they are saying is, if you try to share your views or opinion through a newspaper or through some other medium other than this social media, which is through the internet, there might be a huge cost will available. करेक्ट नो कि तुमको अधिक खर्च करिया पड़े, बट तमे इंटरनेट रे मे बी तमे बिना मतलब कोनोसी पैसा न देगी भी तमे कोन करि परियो, तम व्यूज को एक्सप्रेस करि परियो. दैट मींस at somewhat it is also trying to differentiate the people based on the economical class कि जहा पाखरे पैसा अछि ठीक अछि तमे तमरो पब्लिश करो कोथरे पेपर वगैरह रे, बट जहा पाखरे पैसा नै से माने ट्राई करछुली. फॉर एग्जांपल यू टॉक अबाउट दिस रील्स राइट, से गुडा एते व्यूज केमिति मिलुची. करेक्ट नो, बिकॉज से मानु कोनोसी पैसा दवा पडुनी यूट्यूब जेतले चलोतनी. हां ठीक अछि, तांको कोनोसी गोटे चार्ज दवा पडुची रिचार्ज करिया पे, डाटा कंज्यूम करिया पे, बट एटलीस्ट यूट्यूब रे तो से मानु कोनोसी पैसा मिलुनी रील्स बनिया पे. करेक्ट नो. सो एटलीस्ट we are trying to promote these people, like they want to give their views, opinions, so let the platform should be available. Correct? So now what is the afterthought of this? So because of, so what Supreme Court told, this article 14 is not violative of section 66A. 66A lagi article 14 को से violate करनी, but हाँ से 19 clause 1 sub clause A को violate करूची, से 21 को भी violate करूची. So afterthought, they court also talked about something related to hate speech and free speech. So what is this hate speech and free speech? So basically the court told there are three concepts of fundamental to freedom of speech. So what are the three fundamentals? Basically on freedom of speech, there has to be discussion, there has to be advocacy, and there has to be incitement. Please remember what I am saying is, one is a discussion, second one is advocacy, third one is incitement. So if you want to give a view on something, करेक्ट नो कि मते को गोटे ऊपर कुछ व्यू दबार अछि तो मु तार डिसीजन सेतिक बेले नेबी जेतिक बेले ता ऊपर एडिक्वेटली मु डिस्कशन करथिबी देन काहाटू एडवाइस भी नहीं थी कि हाँ भाई एमिति कले ठीक हबो कि सेमिति कले ठीक हबो किंतु जदि ए दिटांग सफिशिएंटली हला एंड एटा जदि लीड कला इनसाइटमेंट को कि मु प्रमोट वर्तन करबी एनिमिटी को then it will become hate speech. Is that clear? Otherwise, for any kind of free speech, you require what? Discussion and advocacy. हाँ कि नहीं? किंतु जदि sufficient amount रो discussion and advocacy ହେଲା ପରେ जदि ताकू तमे incitement सहित जोडुछ to promote enmity, that will lead to offense. Is that clear? Correct, no? Okay. For example, let's talk about कि वर्तमान इलेक्शन टाइम तो मते लागिला कि बीजेपी बीजेडी कांग्रेस को भी पार्टी अछन लेट्स सपोज एक्स वाई जेड तीनटा पार्टी देन मु लेट्स सपोज एक्स पार्टी रो लोक देन मु कोन करली गोटे डिस्कशन स्टार्ट करली गोटे वाई पार्टी रो लोक सहित या फिर निज एक्स पार्टी रो लोक मान सहित डिस्कशन करलु देन एडवाइस नेलु देन आमे गोटे चलला से डिस्कशन एडवाइस एते मात्र रे चलला देन आमे कहलु कि चलो आमे वर्तमान कोन करिया गोटे दंगा पे स्टार्ट कर दवा करेक्ट एंड दंगा कहा का भीतर ना X और Y party भीतर then this is related to incitement and which it will lead to further offenses then these offenses this incitement if it is leading to that 19 clause 2 reasonable ground of restriction then this will coming under hate speech. Is that clear? Hate speech if it will somewhat the discussion advocacy and incitement and that incitement finally leads to 19 clause 2 then that speech will be considered to be hate speech. Otherwise discussion and advocacy supreme court told it is very important to discover the truth and decision making जे पर्यंत ट्रुथ को नल तमे केमिति पाइबो जे पर्यंत तमे डिस्कशन नै करनो तीन चार जनकर व्यूज नै नो ओपिनियन नै नो काटू एडवाइस नै नो देन तमे ट्रुथ केमिति डिस्कवर करिवो तमे डिसीजन केमिति नो सो फॉर डिसीजन मेकिंग फॉर getting the truth these two are mandatory and this can be safe in a safer side, right? Even in incitement if it is not coming towards 19 clause 2 then it is considered to be free speech or else it will be considered to be hate speech. Any doubt? Okay, the next concept, doctrine of severability. So doctrine of severability, what it talks about, for example, because this IT Act 2000, right, we are just removing section 66A, not any other sections. That means, for example, जदि एठी बहुत सारा let's suppose कमला अछि, right, oranges, तो मते लागिला गोटे orange ये टिके सढ़ी गलानी, ठीक अछि जदि ये orange टाकू मु मझरे रखिबी ये कोन करिवो ता साइड रे लागिथिबा जति के orange अछि ताकू भी सढ़े दबो हां कि नै? Correct, no? So what I will try to do is selectively I will try to pick this orange and remove it from the other oranges. तो मु से बास्केट रो से पर्टिकुलरली से गोटे ऑरेंज को उठे देबी एंड ताको बाहर कर देबी ताकि अलगा ऑरेंज गोटा सेफली से ताको काम कर परबे. सेम कांसेप्ट यूज होची कोठी ना जेतले तमे सेक्शन 66 ए को रिमूव करूछ यू आर यूजिंग दिस डॉक्ट्रिन ऑफ सेवरेबिलिटी. व्हाट इट टॉक्स अबाउट कि तमे पर्टिकुलरली 66 ए टा को रिमूव कर देला व्हाइल मेकिंग द आईटी एक्ट 2000 टू बी कॉन्स्टिट्यूशनली वैलिड. Only this section 66A which is considered to be ultra virus, otherwise entire ITR 2000 is not ultra virus. Is that clear? Okay, so we have applied doctrine of severability on section 66A which is inconsistent with the part 3 which is our fundamental right of the constitution, hence it is invalid and struck down. Hope you are clear with Shreya Singhal case, and after that case this section 66A is not there in ITR 2000. Okay,